Hello, I'm Joel Feuer. I'm the Executive Director of the Lowell Milken Institute for Business Law and Policy at UCLA School of Law. This video is designed for entrepreneurs who are interested in protecting their invention through the patent law process. For our discussion today, I'm joined by Eugene Chong. Eugene is a patent lawyer with his own law firm in Pasadena. He received his law degree from UCLA Law, and he has a Bachelor of Science degree in bioengineering from UC San Diego and a Master's of Science degree in electrical engineering from Cal State Los Angeles. In addition to maintaining his own law practice, Eugene runs the Patent Law Clinic at UCLA School of Law. I'm going to ask Eugene some questions about patents and entrepreneurs, but before I start, we have a legal disclaimer. This video is provided for information only and not for the purpose of providing legal advice. Downloading, clicking, or viewing this video does not create an attorney-client relationship with Eugene Chong, the Chong IP Group, or UCLA School of Law. If you need legal advice, you should contact an attorney and enter into an attorney-client relationship. So Eugene, now let's talk about patents and entrepreneurs. Why should an entrepreneur be concerned about patent law?
Well, there's really two main reasons why you should be looking into patents. Is one, you want to protect the invention that your company is working on. So, for example, if your company is a startup and you have some technology that you guys are trying to advance and you want that to be the heart of your company, you want to make sure that you have protection for it, so that when you do actually go out into the marketplace, other people can't copy you. And we'll talk about that more today. And the other reason is you should really be considering what other patents are out there, because when you as a company go out to create your product and you market and you sell it, you want to make sure that you're not infringing on someone else's patent, because when you do that, obviously you're going to have legal issues and people will try to stop your company from creating your product. So these are things that you really want to think about early on before you really get out there.
So let's back up and start with a very fundamental question. What is a patent?
A patent is really, people don't really think about it this way, but a patent is an exclusionary right. Okay, so what that means is it allows you to exclude people from doing something. Okay, and a patent is granted by the U.S. government, and you can think of it as a way of the government giving you almost like a monopoly on that technology or that invention. And it gives you the right to exclude others from, it's very specific, but from making, using, selling, or importing that invention. Okay, so if you think about it that way, if you're creating a technology or an invention, by getting a patent, you will be able to prevent other people from doing those things.
So let's pretend for a moment that I have already created a marvelous invention. How long should I wait before I start this patent process and file a patent?
Well, okay, so that really depends. The sooner the better, obviously, would be the obvious answer, but it really depends on what you've done so far. So if you've got your invention and your technology already created, in the United States, there are very specific things that if you do, you can lose all your patent rights. Okay, so this is kind of the part where you would obviously want to speak with an attorney or a patent attorney, but there are very specific things that you might do that starts a clock. Okay, so just to give you an example, if you publicly disclose your invention, so that would be if you have a Facebook page and you show your invention, a demo of your invention on your Facebook page, that would be a public disclosure. Or if you have an Instagram page or Instagram or any other social media platform, that might be a public disclosure. If you publicly use your invention, so if you go out into the public and you use it, that would be a public use. And if you either offer it for sale or actually sell the product, that would also create this clock, start the clock. Okay, so the problem is in the United States, once the clock starts, you have 1 year from that date to file your patent application. Okay. If you don't file it within that 1 year, you lose all your rights. Okay. Now, you got to be really careful too, because if you want to go international, you don't get that 1 year grace period that you do in the United States. Okay. So internationally, typically, once you do those things, you're going to lose your patent right. So the question of how long you can wait, a lot of times depends on where you are in your stage. If you've been in stealth mode, and your company has been developing and doing testing all in-house, you haven't publicly disclosed it, then you don't have this timeline that you have to get your application in. But if you've actually already pitched your idea or put it on your Facebook page, for example, you really have a year from that date to get your application on file. Because if you don't, you've already lost your rights.
What kinds of inventions are eligible for patents?
Well, typically processes, a machine, composition of matter, or a manufacturer. Those are the things that are listed. But if you really just think about it, if you have a product, that would probably be a mechanical product that might be eligible to be patented. If you've got a system, a unique way of doing things within a system, that may be patentable. If you have a unique process, a method of doing something, that may be patentable. So there's a lot of things that are patentable, but that's not usually the barrier on whether you get a patent or not. Usually it's whether it's already been invented or if it's an obvious variation is going to be the big barrier.
Well, I have heard about utility patents, and then I've heard about something called design patents. What are those? Okay,
so a utility patent is probably what most people would think of when you think of a patent. It is a protection of some utility or function. So really you're thinking about a new functionality or a new utility. That would be a utility patent application. A design patent design application is also a patent application, but a design protects the ornamental appearance of some function or of some product. So if you think about it, you're protecting the way it looks. It's the design. So maybe the iPhone may have many patents on the phone and the functionalities, but it'll also have many patents on the design. It's the way it looks. So it might be the placement of the home button, or it might be the shape of the actual case of the device itself. Now, those things you're gonna apply for applications for design because it's the ornamental look of it.
So something like a steam engine or a folding chair would be a utility patent. Generally.
Yeah. So if it's a new way of using a steam engine or a novel way of using a chair, the way it folds, that would be a utility application. But they're not mutually exclusive. You can actually apply, and many times many companies do, you would apply for the way it looks and also the way it functions.
So a design patent would be something like the bottom of a tennis shoe. For example, the way the tennis shoe is designed at the bottom.
Yeah, sure. Yeah. The sole of, or even the whole shoe itself, the unique way it looks, because it's pretty easy to copy someone the way something looks. So you might want protection on that so other people can't create the exact same looking thing.
So I've heard something called a provisional patent application. And what is that, and why would you ever file one?
A provisional application it doesn't get examined at the USPTO. So you file the application and it essentially holds your place in line. Okay. And it buys you 1 year from that filing to file a non-provisional application based on the provisional. Okay. Now, what the provisional application does is it's a lot cheaper. Okay. And it never gets examined. Once you get that filing date of your provisional, when you go to file your non-provisional later, you can claim priority to that provisional application. Now, what that does is that year it buys you. In that year, you've delayed the prosecution costs. So you haven't started the heavy cost of filing a non-provisional application and doing the prosecution through the USPTO. Once you bought that year, you can do a lot of things. You can try funding, you can develop further. Now, the one thing you want to be careful is in the provisional application, it should have everything that you're going to later put in your non-provisional, because in order to claim the priority date of the provisional, it has to be supported in the provisional. So sometimes what people might do is they might just file a slide deck as their provisional application. Because think about it, it never gets examined. It just has to give you the priority date. But the catch about that is if it doesn't have all the information that you need that you later claim, you may not be entitled to that priority date. Okay. Now, the other reason why you might file a provisional is, let's say tomorrow you're going to go live and you're going to demo your product at a trade show. Now, by you doing that, as we talked about, that's a public use, okay? Now, you want to get something on file before that because, like we talked about, your international rights might be lost if you don't have an application on file. So by filing the provisional before those things, when you go to file your non-provisional or international application, you claim priority back to the provisional date filing. So you're in front of your public disclosure at the trade show. So now you haven't lost your rights or your clock hasn't started. So, I mean, a provisional is a really nice way for startups and early on companies to get something filed at the USPTO. Now, again, the catch is it has to be substantial. I mean, a lot of times what I would prefer to do is almost write a full application and file it as a provisional. I mean, that's what I would recommend. But just by filing the provisional, you're delaying a lot of costs. The attorney costs are cheaper. The filing costs are cheaper. So that's really the main reasons why you'll probably want to file a provisional application.
So it sounds like one of the questions that an entrepreneur should have for a lawyer going into a first conversation is, do I need to file a provisional based upon the facts and circumstances of what I want to do when, in fact, I want to make this invention available to the public or show it to investors or put it on my Facebook page?
Yeah, absolutely. That would be a great question to have when you speak with a patent attorney, and they'll be able to give you the exact timeline and what bar dates you might have. But again, it lowers the cost, so it always really helps to, especially early on in a company's patent costs can get really expensive fast, so it lowers the cost earlier on.
So you started to tell us a little bit about the patent process. Why don't you describe for us what that process is of obtaining a patent from application to obtaining the patent? Okay,
so when you file, we'll backtrack a little bit. So what you'll want to do first is you'd have to, before you file the application, you'd have to get the application drafted. Okay, so remember, a patent is a very specific legal document that has requirements set by the USPTO, and it has to meet these requirements. So, I highly recommend having some patent professional assist with your application. Now, once you get the application drafted, you're going to go ahead or the patent attorney and their firm will go ahead and file the application with the USPTO. Now, if you file the provisional application, nothing will happen, right? Because we just discussed nothing happens with the provisional. If you file a non-provisional, what will happen is you'll get what's called a filing receipt, and it'll give you the formalities of who the inventors are, the applicant, the filing date. Again, really nothing happens after you file your non-provisional application from your point of view, because the USPTO will typically take anywhere from 12 months to 36 months before you hear anything back from the USPTO. Now, in that time, you filed it and you go ahead and keep doing what you're normally doing with your company and your startup. But what the USPTO will do is they'll make sure all the formalities are met, then they'll assign it to an examiner, and an examiner will then do a search of their databases to see if there's any prior art that came before your application. And likely what's going to happen 95% of the time, you're going to get what's called a rejection. You shouldn't really It's in every application. You get a rejection from the USPTO, and that's the examiner's opinion as to why your application shouldn't be allowed. But that's pretty standard, and you'll work with your patent attorney to draft a response to that rejection. And what you're doing at that point is called patent prosecution. You're going back and forth with the USPTO. Your attorney as your representative, is going back and forth with the USPTO to convince that examiner that why your case is novel. It's a non-obvious variant of the art that he cited. So again, you've already waited 12 to 36 months, and then you go into prosecution. Now, it could be fast, but it could also drag on. So that could take anywhere from 6 months to 30 months before you have a final determination as to whether your case is going to be allowed or not. And again, there's things that allow you to extend that, so you can file what's called a RCE, request to continue examination, after a final. It buys you more time. Obviously, you have to pay fees for that. But at the very end, you'll get a determination as to whether they're going to allow it or not. And then once they allow it, then after some time, few months, and all the formalities are met, they'll grant you an issued patent. Okay. And now, your company has an issued patent, and the issued patent is now, you can use it to exclude other people from doing what you've claimed in the issued patent.
I see.
Yeah.
So when an entrepreneur comes to you as a brand new client and says, I want to patent this invention, what kind of information should the entrepreneur bring to you? What information do you need in order to begin this process?
We're going to deep dive into the technical aspects of the invention or product. Okay? Because the patent attorney is taking the invention that your company has created and turning that into a patent application. So you should go in with all the technical details, because the patent attorney himself or herself will also have technical expertise. Typically, they'll have an undergraduate degree or some experience in that field that you're in. They'll be able to converse with you about the invention. And really, the job of the inventor is to bring the technical invention to the patent attorney, who then turns that into an application. So you might bring your slide decks, you might bring a prototype, you might bring a paper that you've written. All of those things will help the patent attorney. Now, typically that's called a inventor disclosure meeting that the patent attorney will have with you. It could be live or it could be through the phone, but that will get the patent attorney going, and he'll have the information he needs to get an application drafted for you to review.
Is there an issue about who owns the invention when you apply? Is there an issue between the inventor and perhaps the company that the inventor worked for? Or
there can be. You'll want to speak with an attorney if you think that that's an issue. Now, a lot of times the inventor is the CEO or the founder of the company. And at that point, there's really not much of an issue, right? Because it's the same person. But if you're a company and you're a startup, most likely you've already registered your company name and you already have a business going. Typically, what would happen is any employees, including yourself as the founder or CEO, would assign your rights in your patent to the company, and the company would own the patent. So when you go to apply for the applicant would typically be the company, and you will be listed, or the employees will be listed as an inventor. Okay. Now, then what would happen is the inventors would assign their rights to the company. Okay, and the company would own the application or the rights to the application. That kind of brings up really a good question about who is an inventor. Okay, now again, that's a legal definition that you're going to want to speak with an attorney about. But a lot of people may contribute to the invention. So you got to be careful as to who gets listed as an inventor and who doesn't, because it's really important, because that's one of the requirements. You have to list the true and correct inventors, or later on you could actually invalidate, or someone else could invalidate your patent because you have the wrong inventors. Okay, and just generally speaking, who's an inventor comes down to conception and reduction to practice. Okay, that's so if you come up with the product idea, and then if someone reduces it to practice, that's kind of a framework that a lot of people will use in determining who's an inventor. But conception is really the most critical part of that. The person who comes up with the idea, definitely should be listed as an inventor, even if it's a small piece of it. Inventorship will always follow the claims. So in a patent application, at the very end of the application, there's a listing of claims. Now, the claims are what define your rights. Mm-hmm. And whether you're an inventor or not follows the claims. So let's say, Joel, you and two other people came up with the product, but in the final end claim set, the part that I or the other person came up with is not in the claims, and the other person probably isn't an inventor because the inventor follows the claims. Inventorship follows the claims. But at least in the beginning, when you go ahead and file your application, you're going to want to list all the people who helped come up with all the ideas for that product.
And when the entrepreneur comes to you, if the entrepreneur himself or herself is not the inventor, that there are other people who are involved, do you want to speak to those people? Do you typically want to have some contact with them to understand what their roles are?
Yeah, because as a patent attorney, when I go to draft the application, the inventor meeting to learn more about the application will be done with the people that created the product. Okay, so the person who is the CEO of a company that didn't create the product, to me as a patent attorney, would not be that helpful to speak with outside of the formalities. I would want to speak with the actual inventors because they're going to have the technical knowledge and the information that I need in order to turn that into an application.
So I want to go back to something that you said in terms of what happens in the process. You explained that once you file the application, not the preliminary application, but the application that is actually examined, one of the things the examiner does is goes through their large database to see if there's prior art. That is, did someone else invent this first, or someone invent something very close to it, to see how that connects to what you're proposing in the application. As the attorney for the patent applicant, do you also look at prior art before you file? Do you have a way of analyzing it?
Sometimes I will. It's going to depend on the budget of the company. Now, if you want to do a full search before you decide to file your application, you can get that done. A patent attorney can do that for you. And typically a patent attorney, nowadays you can go on Google Patents and use keyword searching. You could actually have access to the USPTO database. But essentially what we're looking through is prior patent applications. To see if there's things that have already been filed that have or are very similar to what you're trying to do. Now, when you file your application, there's what's called search fee. You're paying the USPTO to do the search for you, right? So in a way, it kind of defeats the purpose to pay a patent attorney to do the search because it a lot of times will not match up with what the patent office will find on their own. Okay. But again, if it's really early on and you just want to know, hey, is it worth spending the money and time to go down this product? Then you might have a patent attorney do a search for you, a short search to see if there's something out there and give you an opinion as to whether they think you have a chance or not of getting a patent granted. So you can have that done.
I see. Okay. Yeah. So what about patents in countries other than the U.S.? You mentioned before international patents. And I take it that many inventors and entrepreneurs and companies want protection outside the United States as well because they have plans to sometime expand outside the United States. What about those? What about patents in those countries?
So there's not a thing called an international patent, but we use that roughly to speak about any country outside of the United States. Now, patents are jurisdictional specific. So a U.S. patent is for the U.S., obviously. And if you get a patent in Europe, it'd be so. Now, there is an application called the PCT application, and that's the international application. And the PCT is an acronym for the Patent Cooperation Treaty. And many countries are participants, including the United States, are participants in this treaty. And you could file one international application, okay, with a receiving office. So the USPTO could be the receiving office. And then after a certain amount of time, you can go into the other countries that you want. So really, you could think of it as a launch pad. Now, the time that you have to file in these other countries is typically 30 or 31 months from the earliest priority date of that application. So remember, if you filed a provisional application and then within a year you filed an international PCT application, you're claiming priority back to the date of the provisional application. So within 30 to 31 months of that filing date, every country varies, you're going to have to file an international or national application based on the PCT application in the country that you want. Okay, so you might want China. Okay, so using your international application, you would then file an application in China based on your PCT international application. And now, whether it makes sense to file in a specific country is going to be a business decision, because there are costs to get the application granted, and then there are costs to enforcement. So that becomes a later decision that you have to make, because, obviously it's going to get, depending on how many countries you get or you want to go into, the cost can vary significantly. Mm-hmm. And enforcement in certain countries may be easier or not easy. Those are all things you might, if your invention is for skis, then you're going to want to look at countries where skiing is very popular, but you're not going to really care about countries that don't do skiing. So all of these things will factor into whether you're going to file internationally or not.
So taking up on that theme about where to file and where to invest money, there does sound like there's some real complexity here in getting a patent, both in the United States and internationally. So it made me think, well, maybe I don't need a patent. Maybe I shouldn't even bother with a patent. Tell me about the relationship between having a patent and getting an investor.
Yeah. Well, again, like we discussed, the patent is an exclusionary right. So if you get a patent granted, you can exclude people from doing a specific thing. Now, if you don't have that, you can't, or you don't have the legal basis to exclude. So imagine that you go on Shark Tank and one of the questions that will always come up is, do you have patent applications filed? Because the investors are going to want to know whether you can exclude people from doing this. Because as soon as that show airs, there may be 100 different people who think that's a great idea and start selling it on Amazon. You essentially have your recourses are very limited. Now, if you don't have a patent, how would you don't have a basis to stop them. Okay. So depending on the product, if the product is a very functionality-based product, this may be very important. Or if it looks a certain way, a design patent might be very important. So it's going to, again, depend on the product and the investor. But I think many investors are going to really want to know and would really like to know how many applications you have filed.
Okay. So what does it cost to obtain a patent in the United States?
It's going to range. But the fees, the USPTO fees are set. So if you file a provisional application, the fees are fairly low. The fees are based on your entity status. So if you qualify as a micro entity, and a patent attorney will be able to talk you through that, or a small entity or a non-discounted large entity, the fees will vary. But for a provisional, micro entity is only going to be $70 or $100, and for a large entity, it would only be a couple $100. So that's really not the part that's going to cost you a lot. But you have to typically get a patent professional to draft the application for you. So a provisional application can range anywhere from $3,000 to $5,000. Again, it's going to vary depending on the firm or the practitioner you use and the technology and the complexity of it. For a non-provisional, the filing fees are a little more substantial. They go into as a micro entity, $400 to as a large entity, almost $2,000. And again, the fees for the attorney will vary, but typically to get a non-provisional drafted from scratch, it might cost you anywhere from $5,000, $6,000 to $10,000 to $20,000, depending again on the practitioner and the technology. And a design application will typically be a lot cheaper because there's not that much that goes into a design application. But the filing fees are about a couple $100 for a micro entity to about $700-800 for a large entity. And the attorney fees will typically range from $1,000 to $2,000. Now, the one thing is you'll be asking what's a micro entity and a small entity and a large entity. Typically, a small entity is 500 employees or less. So almost most startups are going to fit that bill. And even for a while, you won't have 500 employees, so you'll fit that bill. So that gives you half the cost of a large regular entity. So a large entity would be, Sony or any large company. So your USPTO filing fees would be half of the large entity. A micro entity is a special status, and that would depend on either you or the inventors, every inventor or the company's income. And that ranges. That's a multiplier of the federal, some federal limit. But I checked recently, it was about 180,000. So if you're under that limit and you filed less than a certain amount of applications, then you could qualify as a micro entity. But again, a patent attorney would be able to walk you through that.
So you talked about the fact that once we file the application and it's examined, there's a high likelihood that the examiner will reject, at least in the first instance, and you as the attorney will go back and explain why, in fact, they shouldn't reject it and should accept this patent. And there's a back and forth and back and forth. But let's assume for a moment that, in fact, you're unable to persuade the examiner that the patent should be granted. I'm sure that never happens with you, but let's just assume that. Can I still use my invention even though the patent office has rejected the patent?
That's going to also depend on so the examiner is going to cite different art to you, but really it's what other patents have been granted in that space. Now, if there's a patent that covers what you're trying to do, then the answer to that would be no, because the owner of the previous or the owner of the previous patent that's been granted will have the federal right to exclude you from it. So really the answer would be no. Now, but if there is no patent, granted patent covering exactly what you're doing, then likely the answer could be yes. Again, you would not be able to exclude others from doing what you're creating now, but whether you can use it now, the answer will likely be yes. But again, that is pretty intricate because whether someone could sue you for patent infringement, the barrier to suing you is very low. Okay, so whether they can sue you or not, that's a different question. But whether they can actually ultimately stop you, if their patent claims cover what you're doing, then they may be able to. Yeah.
So sometimes, I'm putting together an idea for a company or a business or a new invention, or what I think is a new invention, and I have to use something that is already patented as part of my entire process, right? Can I use that? Can I go forward and use that even though someone else has a patent on that part of it?
No. I mean, the simple answer is no. The way they'll stop you is if they sue you for patent infringement. But if they have coverage on a subpart of what you're doing, then they have the right to exclude you from doing that. So if your invention requires A, B, C, and D, right? And there's a patent out there for A and B, okay? By you doing A, B, C, and D, the person who owns the patent that covers A and B would be able to stop you from doing the AB part of your A, B, C, and D. So by you adding onto it doesn't mean you've created something new. You're essentially, or you probably are still infringing on the earlier.
So is there something I can do about that?
So you'd want to talk to a patent attorney, and you can, what a lot of companies or a lot of people would, if it's essential, you would probably try to get a patent license. And a license, a patent license is essentially it's a contractual agreement between you and the owner of the patent, and they're giving you a license in exchange for whatever it may be. It may be for, for money, or it may be for part of your company, or it may be for a cross license for patents that you own. But you're exchanging, that owner of that patent is giving you a license or a right to use their patent. So, and that could take many variations. It could be limited to a very specific technology field or a very specific region. But I mean, really the easiest, or one of the ways you would go around that, is you'd want to contact the person who owns the patent and potentially get a license from them. And
in doing that, is that something that you would help do as a patent attorney?
Yeah, so a patent attorney could assist you with that. Now it is a specialized kind of field. So some patent attorneys or attorneys will specialize in that, the licensing aspect of it. But your patent attorney will probably have enough expertise and knowledge to get you going there.
So besides patents, are there other ways to protect innovations?
There are. Intellectual property, generally, patents are just a portion of it. So again, this is this could be a business decision for the company, but other things that you'll want to consider is a trademark. Trademark is a nice way to protect. So a trademark is an identifier of services and goods. So, for example, Nike with the swoosh. The swoosh might be an identifier for Nike, or even the name itself, Nike, is not likely. It is trademarked. So what happens there is you've created a brand, and you could protect your company, the brand of your company, so that, let's say you don't have a patent, but you do have a trademark. Someone else can't brand their product with your trademark. Now, a trademark is a lot cheaper, a lot faster, so that's a very nice way to either complement or also protect what your company is doing. And a trademark attorney will be able to walk you through that. But, that's one really good way. Another good way is, copyrights. And a copyright protects artistic expression. So let's say you wrote a book. I mean, that's kind of the standard example, but copywriting, you would copyright the contents of your book. But another really common thing is, let's say you take images of your product, and let's say you hire professional photographers or a camera person to create images of your product, then you put it on your a website. Now, that image would be an artistic expression. You could copyright those images so that someone can't literally copy those images and try to sell your product. Because what happens a lot of times is you might put an image up of your product, and once you get popular, you go on Amazon and someone has the exact same image of your product selling it. Now, in that sense, if you had a copyright registered, then you would be able to stop them, or you would be able to sue, or you'd have rights to sue to take that image down. Okay. If you have a trademark on the product itself and they're using the trademark, you could stop them there. And then the product, as we discussed, if you have patents on it, then you could stop them there. So it's kind of like there's different ways, and they kind of overlap in a sense, but these are things that you'll always want to be thinking about. The last kind of twist that people don't always think about is a trade secret. Okay, so a trade secret might be the secret sauce, okay, or a formula. So Coke might not want to give the sauce away, right? The formula, and keep it as a trade secret. Now, if they were to try to file a patent on the composition, what you have to do is you have to publicly disclose the composition. So Coke might, or their decision would be, it's more valuable for us to keep it a secret because someone can't reverse engineer that. Obviously, that doesn't work very well for many things that you can reverse engineer, but for Coca-Cola, that might be a really good one. And it doesn't have a expiration date. So remember, a patent only lasts, it's very specific how long it lasts. So a utility patent only lasts 20 years, generally speaking, is 20 years from the earliest priority date. Right. So after the 20 years, then you don't no longer have patent protection.
And then anyone can use it without interference.
That's why you see generics once a drug comes off of patent rights, then they may reverse engineer that, and then you have generics, and anyone could make and produce it. Right. So whereas if you had a trade secret, that would not really be an issue for you because you never publicly disclosed it. But again, that goes back to why the U.S. government or a government would give you a monopoly, in a sense, on a technology. They're asking you to publicly disclose everything you know about your invention in exchange for this time period where other people can't copy you, essentially. Now, so that's the trade-off back and forth between you and the government. And that's also why, if you've already publicly disclosed it, that trade-off doesn't really exist, right?
Right.
So that's also why, you have these time periods that you have to file your applications by.
So Eugene, one of the things I know you do is that you run the patent clinic at UCLA School of Law. Could you just spend a few minutes telling us about that patent clinic and who your clients are and who you work with and how one becomes a client?
The clinic is... So the USPTO certifies and clinics throughout the United States. So many law schools now have clinics. Initially, they were kind of on a trial basis, but now I think it's a permanent thing. So many law schools have patent clinics. So you'll have a patent practitioner like myself who has a team. So my team are law students, and they will all have a technical background, and they will be limitedly registered through the USPTO to practice under my supervision. And a person who typically, or a company that's early stage that might not be able to afford the cost of getting a patent or drafting a patent, because really the attorney cost is the cost prohibitive part, might come to a clinic like ours and work with the students and myself to get an application. Now, obviously, it takes us longer, and the goal is the student learns while we get you an application drafted and filed. So there's a back and forth. But it's really nice because while the students are learning, we can also provide a service. And sometimes, depending on how many students we have, we'll determine how many clients we could take on. Like last semester, we took on. We're going to file 6 applications. So if you're on like a bar date, a clinic might not be perfect for you because it takes the time for us to draft it. But a patent clinic could help, people file an application.
So is there a financial cutoff or some sort of cutoff that you use for clients?
We do. Our cutoff is the micro entity cutoff. So you will have to qualify as a micro entity for us to represent you. And again, many times that's based on income. So if you're early stage, at 180,000, I think a lot of people will qualify. So as long as you're early stage and, then we could potentially help you and represent you.
And does the clinic have an application process for clients?
We do have a request for services on our website that you can apply through. Typically, we get hundreds of applications every year, and we can only take, just a handful, maybe 8 to 10. But there are other clinics and other schools, and I think it's worthwhile to give it a try. You put an application in, and it does take a while for us to process all the requests. But if you get in with a clinic could be really helpful.
Great. Well, Eugene, thank you very much for your discussion today about patent law and entrepreneurs. It was very, very useful. And thank you, all of you, for watching our video today.